Getting a divorce in Nevada is actually simpler than you might think. The divorce may be filed in the county where either spouse resides, where the spouses last lived together, where the cause of the divorce took place, or where the plaintiff resided for 6 weeks immediately prior to filing for divorce. One of the spouses must be a Nevada resident for at least 6 weeks before filing for divorce, unless the cause for divorce took place in the Nevada county where the spouses lived. Once the residency requirement is completed, a legal grounds for a divorce must be established. Both general and no-fault divorce are acceptable grounds for divorce. No-fault reasons are incompatibility or living separate and apart without cohabitation for 1 year. The general reason is insanity, which existed for at least 2 years before filing for the divorce. Nevada does not require a parenting plan for child custody. Joint or sole custody is awarded on the best interests of the child and the preference of the child if the child is of sufficient age and capacity, the wishes of the parents, no preferences to be given because of parent sex, whether either parent has committed domestic violence, and other relevant factors. Joint custody is presumed if both parents have signed an agreement or agree in open court. It is also presumed that it is not in the best interest of a child to have a parent who has committed domestic violence receive custody. Temporary child support during the divorce and permanent support may be granted. Official child support percentages are contained in Nevada Revised Statutes, Chapter 125B, Section 070. These guidelines are presumed correct unless the needs of the child would not be met under the circumstances. Deviations from these guidelines are the cost of health insurance, cost of child care, any special educational needs of the child, the age of the child, the responsibility of the parents for the support of others, the value of services contributed by the parents, any public aid paid to the child, any pregnancy expenses, any visitation travel expenses, the amount of time the child spends with each parent, the relative income of each parent, and any other necessary expenses. Nevada is a community property state. The spouses retain their separate property acquired before the marriage or by gift or inheritance. The court divides all community property and property held jointly, including military retirement benefits. Marital fault is not mentioned as a factor. Either spouse's property is also subject to distribution for alimony or child support. Separate property one spouse contributed to purchase or improve community property may be returned to that spouse. Unless there is a premarital agreement, either spouse may be awarded alimony, regardless of marital fault. Alimony may be a lump sum or periodic payments. Nevada has no requirements pertaining to mediation in divorce. Visit us today at www.mydivorcepapers.com and click on Nevada at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.